Hello friends, this is Dr. Sumiti Ahuja, Assistant Professor from Faculty of Law, University of Delhi. In continuation with the previous session, today in Law of Contracts, in the second session, I will be touching upon a very important topic, that is formation of an agreement. This slide here, which you can see on your screen, is highlighting the topics which we would be covering under this session. Firstly, we will be starting with intention, the concept of intention to create legal relationship. Moving on to offer and invitation to treat, that is basically discussing the difference between offer and invitation to offer. Thereafter, we will be proceeding to kinds of offer. Then communication in case of proposal, acceptance as well as revocation. So, herein we will understand that how important is communication in case of offer, acceptance as well as revocation. Then we will proceed to modes of revocation of offer, that is how can an offer be revoked, which has been provided under the Indian Contract Act, and thereafter we will be concluding with today's session after having dealt with the topic of e-contracts. Friends, to start with this topic, intention to create legal relationship, I would like to first mention that whenever we say intention to create legal relationship, what we mean is when the two parties are entering into any kind of contract, they had the intention, or if I may say, whenever the parties are entering into any agreement, the parties at the time of such entering into agreement had the intention to create legal relationship. When I say to create legal relationship, I mean that they had this thing in their minds loud and clear, that if either of the party commits default in fulfilling the obligation or fulfilling any of the terms under the contract, the other party can approach the court to claim relief or to claim legal remedy, as we had discussed in the previous session. Now, it is very interesting to note here that in the Indian Contract Act 1872, Section 10 is there, and Section 10 is the most important provision when we are discussing the general principles of contract, because first we need to understand as to what constitutes a contract. So, the elements or the essentials which have been highlighted under Section 10, I will start with mentioning that there are 3 C's which have been mentioned under Section 10. First C is the consent of the parties, that the two parties are willfully, voluntarily and with their free consent, without any pressure or any force being exercised from anybody, have entered into such an agreement, right. And as we had discussed in the previous session, the definition of contract is an agreement enforceable by law. That is why I am again and again mentioning the term agreement, to tell you that if an agreement possesses all these elements, it becomes a contract. So, after the first C, that is consent, the second C I would like to highlight here is the capacity of the parties, right. So, it is important that the two parties who wish to enter into any kind of contract, they are legally competent to do so. I am saying legally competent because the act itself highlights as to what do we mean by when we say parties are competent to enter into a contract. So, they must have attained the age of majority, and secondly, they must be of legally sound mind, and thirdly, not disqualified under any of the existing laws from entering into a valid contract. Now, the third C as mentioned under Section 10 is consideration, which I had told you in the previous session also, that consideration means something in return. If a person is promising to give you something or making an offer to give you something, you are returning that act of that person by giving something in return. So, if a person is offering to sell you his property, in return of that property, you are promising to give him the requisite money, the amount for the property. These are the 3 C's. Apart from the 3 C's which form the essentials of a valid contract, one also has to understand that there are 2-3 more essentials which have been expressly mentioned under Section 10. So, we have lawful object, we have lawful consideration, and it also says that such an agreement should not be declared to be void under the Indian Contract Act. There is a separate set of provisions which deals with void agreements. We will be discussing that in our later sessions. So, for the time being, you just need to understand that these are the few essentials as mentioned under section 10. Now, why did I tell you this thing at this juncture? The reason for that is that if we talk about intention part here, if we are talking about the intention part here, this intention, expressly this term intention has not been mentioned under section 10. So, section 10 is not saying that there has to be an intention to create legal relationship, but one has to understand that intention is very important. I just told you what we mean by intention to create legal relationship or intention to enter into legal consequences, right. Now, just keep this thing in mind. You can see on your screens that I have made this point here, I have highlighted this aspect here, general presumptions. Why am I talking about general presumptions here? General presumptions, why? And then you can see a classification has been made. So, when we talk about social agreements or family arrangements or domestic agreements or an agreement which you have made with your friend, say that you promise your friend that see today for dinner, I mean tonight for dinner I will be taking you out and the dinner is on me, and consider a situation that due to XYZ reason you are not able to take your friend out for dinner as you had promised. Can that friend of yours sue you? The answer is no, because the parties here never intended legal relationship or legal consequences. That is, if you commit a default in taking your friend out for dinner, your friend will drag you to the court saying that ask this person to take me out for dinner or give a particular amount of money because this person did not fulfill the promise. No, it is not like that, right. So, that is why I am saying here that general presumption is, that in case of social agreements or family arrangements, there the parties, both the parties have not intended legal consequences or legal relationship. So, this is a general presumption. The second general presumption, as you can see here, is that in case of commercial transactions or business agreements, there is a general presumption that both the parties did intend legal consequences. That is, when the parties were entering into a contract, they both bore this thing in the mind that if either of the party commits a default, the other one, in exercise of his or her legal right, will approach the court and claim legal relief or what we call as legal remedy. Now, is this general presumption enough? The answer is, these presumptions are rebuttable in nature. That means, if say in case of a social agreement or a family arrangement, the party, one of the parties is able to prove in the court that no, the parties did intend legal consequences or they did intend legal relations, it can be decided otherwise also. When we say, just if you can see on your screen, I am mentioning one word, that is rebuttable. Under the evidence law, which is now known as Bharatiya Sakshya Adhiniyam 2023, earlier known as Indian Evidence Act 1872, the presumptions have been, the concept of presumptions have been highlighted, and it is clearly stating that presumptions may be rebuttable in nature or irrebuttable in nature. When we say presumptions are rebuttable, we are saying that these presumptions, although there is a general presumption, general belief, but they can be countered or they can be negatived in the court if there is requisite evidence in existence. When we say irrebuttable, we are trying to say that this presumption cannot be discarded, it cannot be contradicted, right. So, here when I am saying that the general presumption is that in case of social agreements or family arrangements, parties do not intend to create legal relationship, I am trying to tell you that presumption is rebuttable and can be proved otherwise. Similar in the case of commercial transactions or business agreements. Now, on this point I would like to highlight case law. So, you can see on your screens here that in the last point, on the last point I have highlighted, I have mentioned two cases, Balfour versus Balfour, Merit versus Merit. Why these two cases, are they similar? Why are the names of both the parties in these cases similar? Through these two cases, I am trying to highlight a point that both these cases involve husband and wife. Here Balfour and Balfour are husband and wife, Merit versus Merit, both the Merits they are husband and wife. But in one of the cases, the court has held that there was a valid contract, parties did intend to create legal relationship, or they intended legal consequences, whereas in the other case the general presumption has been upheld, that is, in case of domestic agreements or domestic arrangements, parties do not intend legal consequences. So, in Balfour versus Balfour, the husband and wife, they had visited a particular country, they had visited abroad, England, but the wife had fallen ill and husband had to join back his job, he had to go back to another country wherein he was working. He had to leave. So, there was an arrangement, if I may say, agreement between the husband and wife, that till the time the wife gets fine, she gets healthy and is able to join back her husband at his place of work, the husband will be providing her with some amount as maintenance on monthly basis, which will take care of her medical expenses and her otherwise expenditure. Later on, so the husband went to his workplace, he started sending the money on as decided, but there was some the relations between them slightly turned sour, and the husband stopped providing that amount as had been agreed between them. So, the wife went to the court in order to claim relief. Now, in this case, before I tell you what the decision was, I would also like to at the same time highlight the facts of the other case. Then let us see what is the difference, then we will be able to better appreciate the difference between the two cases. Now, in Merit versus Merit, again involves husband and wife. So, there was a property which was in joint name of both husband and wife, they were half owner of the half shares in that property. Now, the husband was involved with another woman, although he was married to Mrs. Merit, but he was the husband was involved with another woman, and he wanted to leave the matrimonial house and go with that and to basically join that woman. So, there was an agreement between the two parties wherein the husband had mentioned, because I remember I said they were joint owners of a particular property, that property was mortgaged. So, there was an agreement between the two parties that if the wife is able to clear the remainder of the mortgage money, the debt, if she is able to clear that particular debt, she is able to repay it, husband promised that he would be transferring his half share in the property to the wife. Wife, the relations obviously were not cordial between them because he was involved with another woman. So, wife acted in an intelligent manner that she asked the husband to give it in written that he would be transferring her the half share if she is able to repay the remaining debt, and sign the document. He did. In those circumstances, yes, he did. Now, later when the wife was able to repay the loan, the husband refused or stepped back from his promise. He refused to transfer his half share in the property to his wife. Now, wife also went to the court. In these two situations, the wives had approached the court. In Balfour versus Balfour, when the agreement was entered into, the relations between husband and wife were very cordial, and the court held that they did not intend any legal consequences. It was a mutual domestic arrangement made between the two spouses, and by no means did they intend legal consequences. But that is, the general presumption was upheld. But in case of merit versus merit, different situation. The relations between the husband and wife were not cordial, and the wife knew, she may be having an idea that husband may refuse to fulfill his promise. That is why she asked him to give it in written and put his signature on that document, so that in case he commits a default later or he refuses to fulfill his promise, the wife is able to take necessary action. So herein the presumption, the general presumption was rebutted because of the evidence which was in existence.